Great.
Okay, folks,
So
we are recording. And now I introduce Attorney Michael Mayoral. Mr.
great.
Mayoral, please introduce yourself. Tell us about yourself and your practice.
Yes, thank you, Alexander. Thanks for having me here to the whole group. My name is Michael Mayoral. I'm one of the attorneys and founders of the law firm Perez Mayoral, PA. We specialize and focus on one thing. It's representing homeowners against their associations, both HOAs, condo associations, co-ops throughout the state of Florida. We have offices in Coral Gables, Tampa, and Orlando, and we're opening up in Jacksonville and Fort Myers as well. So it's really throughout the whole state representing homeowners on a number of different issues. And you brought up before starting recording, we were talking about insurance and going into, hurricane season. Really, this was a 1 hour presentation, and we're going to boil it down to 30 minutes. And I'm really happy I was able to sit with you guys before because I could see the type of professionals you are. And I want to try to focus that on the type of professionals you are and issues that both, investors might ask you about, buyers or sellers might ask you about, and to just generally leave you better off with more tools in your pocket. Okay. So I'll go ahead and Alexander, I believe you have to give me permission to share the screen.
If not, I can turn over hosting to you.
Oh yeah, you can do that as well.
Make host. All right, you're the host of the meeting.
Perfect. I got it right here. All right. So the presentation is Before the Storm, Florida HOA and condo property damage issues every owner and association should understand. All right. I'm probably going to be telling Wendy and Michael a whole lot of stuff they might already know already, but I think I might be able to add something there to your knowledge base. So today's topics, we'll go over introduction, legal framework, common damage claims, who's responsible, which is the most important question that's commonly asked in here, insurance issues in general, and then some best practices, immediate steps. Okay. About this webinar, of course, this is not legal advice. This is really educational. This is to help you understand your rights when a hurricane season creates property damage disputes. If you or anybody in the group has a specific issue, knows someone with a specific issue, I've dropped my name into the chat. Please feel free to reach out to me. I love to talk with other professionals about this. I'm a big believer in just having a lifelong professional relationship with people, even if we don't exchange cases, if we just help each other out, it's beneficial to me and hopefully could be beneficial to you as well. Okay, what do we do as attorneys? We represent homeowners, never associations, and just about every dispute you could imagine between a homeowner and an association, both fines, enforcement actions, selective enforcement, property damage claims, a lot of what we're going to talk about today, records disputes. We also do general real estate litigation. We're commercial litigators by trade and do real estate litigation by trade with a focus in HOA law. We also do some general business law and commercial litigation as well. Well, let's go right into the meat and potatoes, so to speak. Condominiums versus HOAs. Okay. And really, I want to try to give you the same presentation I would give a friend or family member, really, to understand this the best. Okay. Everybody calls their association their HOA. Everybody calls a lot of things their HOAs. They call their monthly maintenance dues my HOA. They call their management company my HOA. They call the building my HOA. They call the board my HOA. Really, in Florida, there are different types of associations, but the two most common are condominiums and HOAs. What is the difference? There's two different statutes which govern them. Condominiums are governed by Chapter 718. HOAs are governed by Chapter 720. Usually, rule of thumb, if something is a single family home most all the time and it belongs to an association, that's going to be an HOA. There's no single family homes that are part of associations, which are condominiums. A condominium usually is going to be a large multifamily building, although sometimes you'll see smaller multifamily buildings. Maybe you'll see a complex and it's a bunch of duplexes or fourplexes. Those, when it's townhouses, it might be a condo, it might be an HOA. It really depends on how the property is actually deeded. If you look at the deed of an HOA, it will say the book and page number of the declaration of condominium. If it is a condominium, the deed will almost always, unless there's some error, it will list that it is a condominium. If you know it's an association, but you don't see a condominium listed on a deed, it's most likely a Chapter 720 HOA. Okay. What is the main difference? Basically, there's some core common things. The core common thing is that you have an association, an entity, a board who can regulate use within the property. What does that mean? If it's an HOA, you need to keep your lawn mowed. You cannot have a lot of stuff on your front lawn. You can't let your home get into disrepair. If it's a condo association, it's a little bit different. Condo association is right now I'm in an office building, but this could very well be a commercial condo. And within a condo, the key thing is that you only own what is defined within the condominium declaration as what you own. 95% of the time, what your declaration will say is you own everything within the unfinished drywall. It'll say that your unit begins at the plane of the unfinished drywall. What does that mean? This is a common misconception. Many people will say, "Oh, you own a condo, that means you own drywall in." Not really. Most associations, they own the drywall, you own the texture, the paint, everything within it. This becomes an issue in certain property damage claims that I'm going to go into with you. Also, within condo associations, you have certain rights to get information that you don't have within an HOA. Many people don't know this, but you have the right within a condo building to send written inquiries to your condo association. What are those? Those are questions by certified mail asking about just about anything you want about the association. What people forget about associations is that these are not for profit corporations. When you own a unit, you are essentially almost like a shareholder of Coca Cola, a major shareholder, in fact. You have the right to inspect the books. You have the right to ask questions to the board. And if the board is driving the company into the ground, you have the right to recall the board, to do a recall. And that's one of the most powerful tools homeowners have in fighting a board that's out of control. Okay. So, most common hurricane season damage claims. What do we see? Number one, roof leaks. Roof leaks in Florida are just pervasive. It's all over the place. If you asked my dad what he used to always tell me, it's the sun. The sun in Florida just eats everything alive. And I don't think he was too wrong by that. The combination of things being in a coastal area, the sun beating down on things, just same as car batteries don't last down here as long as they do up north. It's a little bit, these buildings really suffer from erosion. They suffer from erosion. They suffer from property damage issues. They suffer from maintenance issues. But at the same time, all these buildings are suffering, suffering or thriving by the decisions of a board. All buildings are going to have maintenance issues. Each building eventually is going to have things to go wrong with it. What a board does about that has a great amount of effect, and the financial costs to all those unit owners and to just generally living in the building, and a lot more people's ability to really sell the unit. I'll give you examples. Of course, we have Surfside. We have the Surfside building collapse. Terrible tragedy. What happened in Surfside? It was years of deferred maintenance. This board knew that they had issues with the pool deck, with concrete spalling, which is when rebar within concrete starts rusting and expanding. And what did they do? And I'm not someone to blame the board, especially in the Surfside case, because they're dealing with a complicated situation. You have a lot of buildings where a board is dealing with an engineer going to a building, a contractor going to the building and telling them, I believe you have a $10 million repair job that needs to be done. Many unit owners may not want to pay for that. What is the reality? Again, living in an association is like being a member of a corporation or of a company. Sometimes when you're a member of a company, something happens called a capital call. They're not issuing you a distribution. They're asking you to pay money into the company. So that's part of living in a building. It's this push and pull between things that need to be done in the building, the board trying to get those things done, or sometimes ignoring it, and the unit owners kind of suffering the consequences one way or another with that. Okay. So we also see window sliding door damage, exterior walls and stucco of buildings. If that is not maintained properly, or if you have a leak that starts around the window, it could really create a lot of issues with the stucco around the building, and it creates mold within units. You have mold building within walls. Okay, very common in Florida as well. You have pipe and plumbing failures, and you have mold issues. 95% of condo property damage cases are water intrusion related. That's most of the damage in these cases. Now, who is responsible for the damage? Okay. So when you live in a condo building, just like this one pictured on the side, the question is always occurs, who's responsible for the damage here? And you all as professionals might get these questions yourself. Mr. Johnson might get a question from a tenant or from an owner or from a friend saying, I have a leak. The association's telling me that I'm responsible for it, that I have to call my insurance. Or, you have a unit you're trying to sell. And part of the issue is there's a condo leak, there's a leak affecting the unit. Who has to fix that? And this could really stop a sale in its tracks. And I'll tell you why. So within a condo building, there are certain things that are called common elements. What are common elements? Essentially, generally, it's everything that's not your unit, that's not included in the physical boundary of your unit, or which the declaration has not made part of your unit via a clause. Okay. So roof systems are almost always the responsibility of the association to maintain, repair, and replace. This is via statute. A condo association cannot say we are not responsible for maintaining common elements. So a roof is almost always the responsibility of a condo association. I say almost always, I would say 99.9% of the time. Exterior walls are almost always the responsibility of a condo association to maintain, repair, and replace. The common areas, the building structure, slabs, the slabs between units as well. That is a common element. The spaces between the units are common elements. Common plumbing risers, okay, and trunk lines, pools, parking lots, common area, okay. So basically, the rule of thumb is roofs, walls, our own slabs, real structural parts of the building. Check your declaration, but those are almost always common elements. The tricky spot is plumbing, usually, and windows. I have seen condo associations just gaslight their unit owners and tell them, no, the window is your responsibility. What do I mean by that? A homeowner will report a leak to a building. They'll say, building manager, I believe I have a leak. There's water damage all around the window area or above my window area, and I'd like you to come repair it. The association will go out and say, hey, no, the windows in this building are your responsibility to maintain, repair, and replace. A lot of times you actually have to verify them in the governing documents. What ends up happening is that property managers, LCAMs, who are licensed community association managers, manage many buildings, and sometimes they find that out in one building. They worked in a building where the unit owners were responsible for the windows, and they believe that's the law everywhere. So really, who's responsible for what within a building depends on the governing documents. Another big one are pipes. The rule of thumb people use is that if it's a pipe that serves multiple units, then that's a common element. A common drainage stack, that's a common element. That is true. But they'll also say, people will say, if it's a pipe that serves only your unit, then that's your responsibility. Not always true at all. Okay, in a lot of different ways. Number one, that depends on what the governing documents say. There are some governing documents that say within this condominium unit that you're buying, if there is a pipe that serves only your unit, even if it's not included in the boundaries of your unit, even if it's in the wall and you can't access it, it is your responsibility to maintain, repair, and replace it. What does that mean? If your declaration says that and there's a water line, your own water line that leaked and it damaged your unit, you're probably going to have to call your own insurance company. That's probably going to be your only route of recovery. The good news is your insurance usually should cover that depending on the nature of it. Sometimes they'll try to exclude it, saying it's a slow leak. Other times, if it's just a pipe burst, I see unit owners get coverage for that. But the big issue is this, okay? And associations confuse this all the time, okay? All right. There are two things within a building, within a condo association, within your relationship with a condo association. There is responsibility for maintenance outside of a loss, and there is liability. So this is the trick that associations do to everybody across Florida. Okay. And I'm not a conspiracy theorist, but I talk to, I would say, hundreds, if not thousands, of homeowners a year. And this is, I have a video on YouTube about it. You see the same exact attempt to get out of damage. So what will happen? A pipe burst will happen. A roof leak will happen. Something will happen which is which was caused by a common element. Okay. An association will go to a unit owner and tell them, you are correct. The roof is what leaked. However, look at your governing documents. It says here that we are responsible for maintaining common elements. And it also says here that you are responsible for maintaining everything in your unit. And there's even a third clause that says you're supposed to have insurance in your unit. So, therefore, we will fix the roof and you fix everything in your unit. Everything that was damaged by our faulty roof, you fix. And they try to get away with this quite often. They drive unit owners insane. The example I give, which many unit owners have told me, I said that to the association. They still ignored me. It is the same thing in an auto accident. Okay. I own my car the same as I own my condominium unit, and I ordinarily maintain it. It's my job to fix the engine if it breaks, to fix the paint if it scratches. Another automobile owner owns his or her car, and it's their responsibility to maintain it ordinarily. But if that other automobile owner crashes into my car, they are now liable for the loss due to either a breach of a duty, which is negligence, or in this case, if I'm analogizing it back, due to a breach of the governing documents. So what do we do across the state of Florida? We same thing that Wendy does as well. We sue associations who have failed to maintain common elements, which have damaged clients' units, and we recover all the costs to repair the inside of the unit, alternative living expenses, lost rent, additionally, attorney's fees. Something that Alexander said before we began is that if you all might recall this, a couple of years ago, Ron DeSantis signed a bill and enacted a law that ended the ability of insureds to recover attorney's fees against their insurance companies in the case of a lawsuit, which takes away a lot of power of people to sue their insurance companies. That law did not affect condominiums and HOAs. If you sue your HOA or condo association and win, you are due your prevailing party fees. However, it's a two-way fee statute, which means that if you sue your association and get it wrong, you might have to pay their attorney's fees. I don't see that law changing anytime in the future because associations use that same law to foreclose on unit owners when they do not pay their assessments. So most likely that's going to be on the books. Now, there's a really important case here, okay, called McClellan versus Cypress Chase, okay? And I might have a slide on this, I might not. But this is another key situation. So if I could leave you, if I could really teach you a couple things, one thing is be careful with what associations do when it comes to property damage. They will try a lot of different techniques to either get out of it altogether, to minimize what they have to do, to it. I do free consultations on these specific cases dealing with property damage. If you ever have someone who wants to talk it out, I could go through it with them. But there was a case in 2024 called McClellan versus Cypress Chase Condo. And what that case said is that it's this. A condo association has a duty to maintain, repair, and replace common elements no matter who caused the damage to those common elements. Where does this come into play? It comes into play when there's damage between one unit and another unit. So what will happen? Okay, you will have a unit owner, a friend, maybe someone who's trying to sell a unit, buy a unit, and the issue is there's a leak affecting the unit. And it's been determined that the leak was caused by the unit owner above the client, above the subject person. And it's clear it's not coming from the association, it's coming from the unit owner above. Either they have a leaking drain pan or something like that, toilet valve, appliances leaking, God knows what. Okay. A lot of times what associations will do, which is legally wrong and which they can be sued for, is they will tell those two unit owners, once the leak is reported, they will tell them, it's between you guys. This is what we call we're deeming this a unit owner versus unit owner association. Go at each other. Best of luck. Go after his insurance. We don't have it anyways, but best of luck. And unit owners are stuck with this. They're pretty much knocking on someone's door who's not answering, sending text messages that are not being answered to. So what did McClellan say? They said, no, an association is in breach of the statute when that happens. Why? Because the space between the two units, the drywall, is a common element. So when your unit owner, your friend is calling you and they're looking up in their bathroom and they're seeing a big mold stain on the ceiling, the association has breached their duty. What is an association supposed to do? A good association, when that happens, they're supposed to open up the ceiling of the affected unit owner, find out what's causing the leak, make that person fix it or fix it themselves. And then if there's mold, get proper mold remediation, do the absolute correct job on everything. If they do not do that, they are in breach of the governing documents because they have failed to properly maintain, repair, or replace common elements, specifically the common element area between two unit owners. So what is the rule here? There's no such thing as a unit owner versus unit owner problem. Figure it out yourselves. If an association is doing that, they're very, very likely liable, and it's with the right attorney citing the right law, you can get them to do the whole thing and pay for your attorney's fees back. By do the whole thing, I mean properly remediate the damage and stop the leak. This is a rampant problem across Florida. I've represented many seniors well into their 80s and 90s sometimes who are dealing with this, that an association is just letting the unit owner above them leak into the units. Converse situation, okay? You have a unit owner and they say, Wendy, Alexander, Michael, this is the issue. I had a leak downstairs. Something was reported, and ultimately it was some pipe within the wall. And technically, the declaration says it's my responsibility to maintain that pipe. And now the building is saying that I have to pay $75,000 for damage to the common elements, for damage to other people's units. Do I have to pay that? The answer is no. There's no strict liability for unit owner leaks. There's no strict liability for any of these damages of what I'm talking about. Now, what is strict liability for non-attorneys who might need a refresher on that? Strict liability means you're liable regardless of fault or not. You're liable regardless of whether you should have known better or not. Okay. Regular liability, you need to prove negligence or a breach of a duty. Okay. In condo associations, we're usually able to prove this because associations just don't maintain things very well, commonly. If it's a roof leak, usually that roof is 30 years old. They've known about the leaks and they haven't done a damn thing about it. And we can prove negligence through that. If it's a sewer pipe, cast iron pipe, which bursts, usually they have never maintained it in 45 years. So a plumber could pretty much tell you what was wrong with it. But what happens with, water line within the wall? An association will try to tell somebody you're responsible for all of this. And what the law says, the case is Dombrowski versus Blum, water coming from the unit above does not automatically make the unit owner liable. I do not believe that that's a quote. Don't quote that correctly. But essentially what the case says is there is no strict liability in these cases. You need to prove some negligence. In a case like that, a water line within a wall, I don't know how any creative attorney would be able to say that a unit owner should have maintained that correctly. This is common. You might meet somebody who has this issue. We have been highly successful in these cases. Usually we just send a cease and desist and explain what the law is to them. And then the association has to just remediate the issue as a common expense. So it's complicated. These cases with pipes can be very complicated. The rule of thumb, don't accept just what the association or the board is telling you. You need someone to do an analysis of the governing documents, of the facts, and it can make a huge difference. Some people, I've seen some associations just assess somebody on their ledger the amount of damages, not even try to sue them. The person will just log into their software to make a payment, and they'll just see a $55,000 line item. And if they don't not pay that, they're going to have to deal with it down the line. They could start, saying their other payments are late, God knows what. But early and often, call an attorney. We're highly successful in defending these. Okay. So damage in your unit, who's responsible? We spoke about this, but what are things where a unit owner is typically responsible? Damage caused by your own appliances, damage caused by your tenants, guests, or occupants. I had a hilarious case where a client called me and say they're blaming us for setting off the fire sprinklers. They're saying that my brother lit incense, and then I interviewed the association who told me, oh no, the brother showed us YouTube videos that he was wanting to burn cinnamon sticks in the unit, and he set off all these fire sprinklers everywhere. So if you damage a fire sprinkler and it causes damage, and they can prove it, or your tenants cause it, there's plenty of clauses within declarations that say you're liable for the damage your tenants cause. Okay, so I'm pushing against time, but I believe I should be able to go a few more minutes and get through this. Alexander, if you need to pause me at any time, let me know. Okay.
Okay,
Okay.
go ahead.
All right. Association responsibility, damage originating from common elements. One thing that's key here, I want you to see this: incidental damage resulting from common element repairs, and also damage caused by association contractors. This is really important to know about. This is another one of those areas that get passed over, but there's potential liability here. Let's talk about the first one: damage caused by association contractors. What will happen? They'll say, Michael, the issue that was happening, the association was doing a job on the roof, and they let the roof go uncovered and a bunch of rain went into my unit. And who can I sue? What Florida law says is that associations are jointly and severally liable for the actions of their contractors. What does that mean? You could sue both of them. The association is just as responsible for the contractor. It could be that. It could also be I had a case where a contractor stepped on a fire sprinkler while he was checking on the roof and caused a whole bunch of water intrusion. There, both are liable as well. Okay. Now, if you're going after the contractor, that's technically likely a construction defect case. So you're going to want to know what you're doing with that. But both are potentially liable. So don't let an association tell you go after the contractor. Technically, you could go after both. You may want to go after one or the other for strategic reasons, but you could go after both. The other is incidental damage. What will happen? You'll get a call saying the association needs to break into my floor, tear apart my tile to get into the tension rods between the unit. There's rods between slabs, and they need to get in there. They need to do some repair. They're going to destroy my floor, or they're going to take over my unit. I'm not going to be able to live there for 2 months. What can I do? Can I recover? It depends if your declaration has what's called an incidental damage clause. Many governing documents have a clause that says if we cause any incidental damage to your unit during the repair of common elements, we are liable for that damage. The DBPR, the Department of Business and Professional Regulation, has case law, legal opinions that say that also extends to lost rent and alternative living expenses. So you have an argument that if your association is putting you out of your unit or destroying your unit because of their need to repair common elements, which are not caused by negligence, they just need to do a repair, then they have to pay to restore your unit to how it was before and to pay to house you, essentially. We do cases based on incidental damage. This is something an association, I have never seen an association inform unit owners that there's an incidental damage clause in the declaration when they're doing repairs like this. They just try to see if they could get away with it, unfortunately. Not all, but many. Okay. Insurance issues. Okay. And I'm going to try to really run through this. What are the insurance issues we see? We see unit associations confusing homeowners with regard to insurance responsibilities because homeowners must have HO6 insurance. Many times associations try to say, then you're responsible for fixing everything on the inside of your unit. Not true. It depends on liability and fault. Who caused it? Many of my clients don't make a homeowner's insurance claim at all. They just want to go after the association, or sometimes they don't have insurance and we go after the association. What are issues we see associations have with insurance? Some associations are not insured. What do I mean? They do not have the building insured for property and casualty loss. No wind reports, no inspections. They are running without insurance altogether. It is illegal in Florida to do that. Per the statute, associations shall have adequate property insurance, but they are not doing it. What does that cause? It means unit owner. I mean, you cannot sell the unit. You can't do it with conventional financing. Our mortgage brokers would know more about that, but we actually see that. It's rare you're going to see a situation where you're buying into a place like that. But if you have a cash buyer and that's the issue, you really have to look that up because there's probably major reasons why that building's not insured, and there's going to be issues with them becoming insured. This was something that was happening more before the Surfside laws, where smaller buildings were just going on a very, very low cost and not getting the building insured. So what should homeowners do immediately after loss? Find the source. No matter if you're going to sue somebody or not, find the source. Why? You can't sell your unit if there's an active leak. At least I won't buy a building with an active leak. Why? Because the buyer doesn't have the opportunity to fix it themselves. What do I mean? If I'm going to buy a unit and they're saying, Michael, the issue is there's a roof leak affecting the unit, but the association is going to fix it. All that I'm buying is a future lawsuit. Like I might have to sue the association to fix it. I, unit owner, cannot get on the roof and fix that roof no matter what. It's illegal to do. So if you're buying a unit and you have a unit that is being affected by an outside source, for all intents and purposes, you should find out what that source is to stop it, to stop further water intrusion, to stop mold, which affects health, but then to figure out who's liable because it's a huge difference. Do you want to pay $100,000 to fix everything, or should the at-fault party have to pay it? Many times associations have insurance which covers these claims. They have liability insurance, and usually they do, and usually that's who we go after, okay? So put the association on notice. You can make a time-limited demand and escalate when necessary. Usually when clients call me, I ask, did you ask the association to fix it? They said no. Okay, that's about enough. You might need to then go ahead and sue now. What should boards be doing? Okay, get to, first of all, during storms, okay, associations need to have somebody on call in case something happens. Associations don't do this. They need to do prompt inspections. They need to timely communicate with homeowners. Okay, why? Because there's litigation exposure. Okay, consequential damage liability, habitability displacement claims, negligence claims from other owners. And this is not in the slide, but the thing that I would tell that associations have to do, which they really fail to do, and this is the little extra I could give you all, which is really, really important. After Surfside, the laws changed to require mandatory inspections, mandatory structural integrity reserve studies, milestone inspections, which pretty much mandate repairs for all these buildings. Lo and behold, many contracting companies in Florida are being a little bit unscrupulous. I know you're surprised that that could happen in Florida, but many times they're going into these buildings and saying and writing their own bill, writing their own estimate of everything that must be done. And the change orders don't stop. It could be the first estimate's 3.5 million, a building ends up spending 8 million. How does this happen? There's no requirements of education to be on a board. You could be a painter. My brother paints. My dad painted. Nothing against painter or artists, but I'm not qualified to run a multifamily building, and I'm fairly above average lawyer. Your average Joe off the block is not qualified to run a 30-story building with a number of construction issues. Look, these people are similarly not really qualified to negotiate a construction contract or to monitor that construction. What is the best thing to do? If you don't know what you're doing, hire an expert. What a good association should do is, number one, form a construction committee. What does that mean? People within the building who are contractors, attorneys, contract attorneys, GCs, mortgage brokers, who knows what, lawyers, form the committee to analyze these contracts together. You could also hire a contractor to manage the job. All you're paying that contractor to do is to manage the contractors, to make sure you don't get fleeced, because buildings do get fleeced. My friend Christian Murray, this is all he does is analyze these milestone inspection studies, structural integrity reserve studies, and he tells me I have seen gross abuses many times, like on railing they'll double the linear feet of railing you need for a building. No one checks. Change orders, no one checks. So these things really need to be managed properly. I've seen so many buildings after a hurricane loss that they mismanaged the insurance proceeds, and they're still, no one's able to enter their units. They're not able to get the money. Once you run out of insurance proceeds, the money's not coming from, the government. You're going to have to assess everybody to do it. So be really careful if you have a hurricane loss. And hurricane preparedness, check your insurance coverage, of course, make sure you have coverage. Photograph your unit. If you're worried about valuables, photograph them. This is the basics of general hurricane preparedness. And for associations, you have to maintain the building, confirm emergency contacts. And how we help, I said it before, I'm a little bit over time, but we handle disputes across the state of Florida. Anybody who I met with today, if you have somebody facing a property damage or a different dispute, put them together. I love to offer free consultations to people who are referred through me. We normally don't offer free consultations on every case, but you have my contact information there. And I've taken up, you've been so gracious with your time. I think I took a couple extra minutes up. I'll go ahead and stop my presentation. You can visit us at wesuehoas.com. And pleasure to present this to you. And Alexander, if we have time for questions, I'm more than happy to field whatever's out there.
Thank you very much. Do you want me to turn off the recording, or would you
Yeah,
like
sure.
to? Okay.
I don't need to. It's okay. It's up to you guys.